Good evening. My name is Faye Dion, and I am a board member and volunteer attorney with the ACLU of Rhode Island. Last year, the ACLU addressed both the House and the Senate in support of the Reproductive Health Care Act, which is designed to achieve two simple and clear objectives. One, codify the current protections extended to all women in the United States by Roe v. Wade and its later cases, and two, reflect the current state of law in Rhode Island by cleaning up our Rhode Island statute books. Rhode Island law pertaining to reproductive rights is not very accessible to its citizens. On this deeply important subject, our laws are embedded in dense and inaccessible court opinions and obscured behind unenforceable statutes. While it has been more than 15 years since the ACLU has been forced to challenge a Rhode Island law on reproductive rights, here we are again, this time to strongly urge that those hard-fought protections are preserved and not eroded by forces coalescing at the federal level. Many advocates of reproductive freedom are deeply and understandably worried about the future of Roe v. Wade in a reconstituted U.S. Supreme Court. With two new appointments in the last 2 years, both of which were pre-approved by the Anti-Choice Federalist Society and Heritage Foundation, the possibility that a majority of the Supreme Court will re-examine and reject the principles underlying Roe is undeniable. Even if Roe isn't overturned, the court is still likely to chip away at the principles of Roe to the point that a person's ability to make this highly personal and private decision is replaced by a government decision maker. The RHCA explicitly preserves those provisions affecting reproductive choice that are presently in force and conform to Roe v. Wade. It preserves basic informed consent and the requirement of parental or judicial consent for termination of a minor's pregnancy. It preserves the right of individuals who object on moral or religious grounds not to participate in termination procedures. And it preserves that portion of Rhode Island General Laws, Section 36-12-2.1, which prohibits the state from including abortion coverage as part of basic health insurance to state employees. Contrary to some of the other voices you will hear, it changes nothing. It ensures the status quo of reproductive freedom in Rhode Island and ensures that the many provisions previously struck down or never enforced as unconstitutional are now formally repealed. Last year, my colleague Lynette Lee Berger and I prepared a 6-page memo and a 1-page fact sheet which directly refuted the unfounded claims of critics of the RHCA. That same legislation, House 5127, is before you. Now a new bill, House 5125, is being proposed as an alternative to the RHCA, when no new bill is necessary. Unlike the RHCA, this alternative bill is not designed to and will not achieve the simple and clear objectives of codifying current law and repealing unenforceable law, doing nothing more or less. My colleague Lynette Lee Berger will address those differences in her presentation. We urge legislators, having all the facts and fully recognizing the present vulnerability of the principles of Roe v. Wade, to choose to protect the rights and health of Rhode Islanders by passing the RHCA this year. After Ms. Lee Berger's testimony, we'll be happy to take questions. Thank you.